This is the WCAG Wire for Saturday, January 10th, 2026. Current standards: WCAG 2.2, ADA, Title 1, 2, and 3, Section 508. Information verified as of 1900 UTC. Bottom line up front: federal and state courts issue 4 significant disability accommodation decisions addressing workplace modifications, arbitration scope, and exhaustion requirements. District of Columbia Federal Court grants intervention in MPD class action for individual damages. Pennsylvania Commonwealth Court affirms arbitrator's authority to order full online teaching accommodation for university professor with post-aneurysm disabilities. D.C. Federal Court grants summary judgment, dismissing federal employees' race and sex discrimination claims on exhaustion and merit grounds. Eighth Circuit affirms summary judgment for hospital and physician assistant termination case, holding shift scheduling constitutes essential job function.
On January 9th, Judge Rudolph Contreras of the U.S. District Court for the District of Columbia granted former MPD officer Vincent Hopkins's amended motion to intervene in Pappas v. District of Columbia, a certified class action challenging the Metropolitan Police Department's disability retirement policy. Hopkins, who was disability retired in March 2022 after developing post-viral COVID syndrome, sought to intervene as a member of Subclass 2 to pursue individual monetary damages. Civil Action Number 19-2800. The Pappas litigation involves current and former MPD officers alleging that the district violated Title I of the ADA and Section 504 of the Rehabilitation Act by implementing a disability retirement policy requiring officers who spend 172 cumulative workdays over 2 years in less than full-duty status to undergo forced disability retirement without providing reasonable accommodations. The district court certified a Rule 23b2 class in March 2024, and subsequently ordered notice to absent class members despite Rule 23c2 not requiring notice for injunctive relief classes.
Judge Contreras reasoned that, quote, given the risk that a future court would bar absent class members' individual damages claims, if those class members were to seek damages in future individual suits, the court believes that it is consistent with due process to provide absent class members with notice and an opportunity to intervene or seek to opt out. The court set a January 23, 2026 deadline for intervention motions. Hopkins timely filed his initial motion but failed to state grounds or include a proposed complaint. The court denied without prejudice with leave to amend. Hopkins filed an amended motion seeking permissive intervention under Rule 24b. The district opposed, arguing intervention would cause undue delay and confusion. Judge Contreras granted intervention but imposed significant limitations. The court held Hopkins satisfied Rule 24b's requirements: independent subject matter jurisdiction through federal question jurisdiction, timeliness, and common questions of law and fact with the main action. However, to avoid confusion and delay, the court restricted Hopkins's intervention solely to pursuing individual monetary damages, not declaratory or injunctive relief separate from the class.
The court explained that allowing Hopkins to intervene for separate injunctive relief, quote, would complicate the resolution of the class claim and undermine the purpose of the certification of a Rule 23b2 class. Judge Contreras emphasized that Rule 23b2's key feature is, quote, the indivisible nature of the injunctive or declaratory remedy warranted, the notion that the conduct is such that it can be enjoined or declared unlawful only as to all of the class members or as to none of them. On the delay issue, the court rejected the district's arguments. First, the district's anticipated motion to dismiss Hopkins's Section 504 claim would not meaningfully delay proceedings because discovery relevant to individual damages does not depend on statutory basis. Second, although the district anticipated needing discovery on Hopkins's accommodation requests, income, employment search efforts, and medical information, the court noted discovery has not yet closed and saw no reason one additional individual's damages discovery would cause meaningful delay.
Judge Contreras concluded Hopkins, quote, appears to have precisely followed the class notice's instructions to pursue monetary damages, which would make denial unjustified, absent prejudice showing. The court noted vicarious exhaustion would likely apply to Hopkins because his claims are similar to named plaintiff Pappas's claims, meaning Pappas's EEO filings could have put the EECC or MPD on notice. On January 9th, the Pennsylvania Commonwealth Court affirmed an arbitrator's award directing Pennsylvania Western University to accommodate Professor Urena Pack's disability by permitting fully online teaching. Judge Patricia McCulloch's opinion held the award drew its essence from the collective bargaining agreement's disability accommodation provisions incorporating ADA standards. Case number 1424 CD 2024.
Professor Pack, a 20-year English professor at the university's Clarion campus, suffered a brain aneurysm in 2019, requiring multiple surgeries. She developed permanent limitations, including short-term memory loss, speech impairment, and chronic pain and headaches. The university approved fully online teaching for 2.5 academic years. For 2023 and 2024, however, Executive Director Amy Salzgiver denied Pack's accommodation request after meetings with administration that excluded Pack, concluding in-person instruction was an essential function. Pack was assigned 2 in-person and 2 online courses for fall 2023. Pack filed a grievance under Article 3 of the Collective Bargaining Agreement, which provides that, quote, where existing laws against discrimination require accommodation, the university will accommodate to the extent required by law. Arbitrator J. Nadelbach sustained the grievance, finding the university's accommodation denial violated the CBA's incorporation of ADA requirements. The arbitrator concluded the university's decision-making process was a, quote, sham, because Pack was excluded from meetings determining her accommodation. The arbitrator found, quote, no reliable support for the contention that face-to-face instruction is an essential function of a faculty member's position, noting no CBA provision, job description, or course catalog established in-person teaching as essential. The arbitrator rejected the university's argument that Article 41's voluntary distance education provision implied in-person instruction was mandatory, reasoning that, quote, making online teaching voluntary does not mean or even imply that face-to-face instruction is somehow an essential job function. On undue hardship, the arbitrator found no credible evidence that Pack's accommodation would result in significant financial or operational cost, noting many other English courses continued to be scheduled online. The university appealed, arguing the award violated managerial rights under Article 10 of the CBA and Section 702 of the Public Employee Relations Act, and failed to properly apply ADA requirements. Judge McCulloch rejected both arguments under Pennsylvania's highly deferential essence test. The court held the award plainly derived from Article 3's incorporation of ADA standards. Citing the Third Circuit's framework, the court noted ADA failure to accommodate claims require showing disability, employer notice, ability to perform essential functions with reasonable accommodation, and employer's failure to provide reasonable accommodation. The arbitrator analyzed each element, rejected the university's essential function claim based on lack of documentary evidence, found inadequate interactive process, and determined no undue hardship existed. Judge McCulloch distinguished the university's managerial rights argument, explaining the award, quote, does not ignore, run afoul of, add anything to, or delete anything from Article 10 of the CBA. It simply reads Article 10 as contractually limited by Article 3. The court emphasized the arbitrator did not direct hiring, firing, course modifications, or relaxed standards, but rather ordered a specific accommodation the university had already provided for 2 years. On public policy, the court rejected the university's claim that the award usurped managerial authority, holding that even if the award implicated managerial rights, it does not violate them because the university contractually agreed to limit those rights through Article 3's ADA accommodation requirements. On January 6th, Judge Carl Nichols of the U.S. District Court for the District of Columbia granted summary judgment to the Department of Veterans Affairs on all remaining Title VII claims brought by employee Sylvia Dunn, holding she failed to exhaust most claims and could not establish discrimination or retaliation on the merits. Civil Action, Number 1, 21 CV 02845. Dunn, an African-American woman who served as Director of Resource Management, alleged Supervisor Kevin Hanretta excluded her from Human Resources Council meetings beginning August 2016, undermined her authority, removed responsibilities, and elevated male staff members. Dunn filed an EEO complaint in November 2017, alleging sex-based hostile work environment, harassment, retaliation, pay discrimination,
and disability discrimination. An EEOC administrative judge granted summary judgment to the agency in July 2021. Judge Nichols first addressed exhaustion. The court held Dunn failed to exhaust all race discrimination claims because her EEO complaint contained no race-based allegations whatsoever. Dunn, quote, wrote nothing whatsoever about race in her EEO complaint, which referenced only sex-based harassment and hostile work environment. The court further held Dunn failed to exhaust most sex discrimination claims because hostile work environment claims and discrete discrimination claims are, quote, different in kind. Exhausting one does not exhaust the other. The EEOC interpreted Dunn's complaint as raising only two discrete acts, separate from hostile environment: denial of telework as reasonable accommodation addressing disability, not sex, and reassignment of EEO responsibilities to Executive Assistant Davis. Only the latter discrete sex discrimination claim survived exhaustion analysis. However, even this surviving claim failed because Dunn's complaint did not include the EEO reassignment in its list of allegedly adverse sex-based actions. Judge Nichols held plaintiffs cannot, quote, use summary judgment briefing to press claims not raised in their complaints. On retaliation exhaustion, the court held Dunn exhausted only 5 specific acts alleged in her amended EEO complaint: privacy breach from sharing EEO information with subordinates, isolation of responsibilities through removal of supervisory role over 2 GS-13 positions, position management alteration, delayed 2017 performance review, and exclusion from HR council meetings. Notably absent was any exhausted claim about fabricated accusations against Dunn.
On the merits of the surviving EEO reassignment sex discrimination claim, Judge Nichols held Dunn failed to establish a prima facie case. The only evidence was Dunn's conclusory interrogatory responses, lacking specific details about which EEO responsibilities were removed. The government presented affidavits stating duties never changed, and employment records showing EEO responsibilities consistently remained in performance plans. The court found Dunn's lack of specific evidence fatal, explaining, quote, absent any concrete examples or evidence to support her allegations, the court concludes that plaintiff has failed to establish a prima facie case of discrimination. Additionally, Dunn failed to establish an inference of discrimination through comparator evidence. All of Henrietta's other direct reports were male senior executive service members, while Dunn was not SES. The court held comparators being, quote, above or below plaintiff's pay grade is classic evidence they were not similarly situated. That Henrietta allegedly transferred Dunn's EEO duties to Davis, another woman, further undermined any sex discrimination inference. On retaliation, Judge Nichols held multiple claims failed for pleading deficiencies because Dunn's complaint alleged only that she, quote, faced retaliation when she was harassed and intimidated by fabricating false claims against her, not the broader set of retaliatory acts she raised in summary judgment briefing. Even considering exhausted retaliation claims, the court found fatal evidentiary deficiencies. For the EEO responsibility reassignment claim, Dunn provided no specific evidence of removed duties. For the alleged privacy breach sharing EEO information with subordinates, Dunn admitted emails were her only proof, but those emails showed Henrietta quickly removed a subordinate from any involvement. For the GS-13 supervisory change, the court found no evidence that having more indirect supervisory responsibilities was materially adverse. On causation, Judge Nichols held temporal proximity between Dunn's November 2017 EEO filing and alleged retaliatory acts was too attenuated. Claims discovered in March 2018, over 4 months later, exceeded the temporal proximity that could support retaliation inference, citing Taylor v. Solis's holding that 2.5 months was too long. The court emphasized that when, quote, the chief evidence relied upon by the plaintiff to establish the causal connection is the temporal proximity, specific dates are required. Finally, the court rejected Dunn's HR council meeting exclusion claim on causation grounds because emails showed the exclusion decision occurred in August 2016, over a year before her November 2017 EEO complaint. Judge Nichols held, quote, retaliatory motives cannot be inferred from a course of action that began prior to protected activity. On January 5th, the Eighth Circuit affirmed summary judgment for Mercy One Siouxland Medical Center in physician assistant Michelle Siebrecht's ADA, ICRA, and FMLA claims, holding shift scheduling requirements constitute essential job functions. Judge Levensky Smith wrote for the panel.
Case number 24-3159. Siebrecht, diagnosed with multiple sclerosis, worked as emergency room physician assistant at Mercy's Hawarden, Iowa Critical Access Facility, requiring 24-hour provider staffing. Siebrecht's contract required 3 24-hour shifts per 2-week pay period and weekend coverage. After MS-related FMLA leaves, Siebrecht's physician cleared her to return to work in February 20, 2022, with restrictions. No more than 1 24-hour shift weekly, and no weekend shifts, with restrictions expected through December 31, 2022. Mercy terminated Siebrecht's employment effective May 30, 2022, stating the parties had not renewed her employment contract, which expired February 28, 2022. Siebrecht never made a counteroffer after Mercy presented a contract extension in January 20, 2022. By late May 20, 2022, Siebrecht's physician released her to return to work with no restrictions. On disability discrimination, the Eighth Circuit applied the 2-part qualified individual test requiring possession of requisite skills and ability to perform essential job functions with or without reasonable accommodation. The court held Mercy met its burden of establishing 3 24-hour shifts per pay period and weekend shifts as essential functions based on employer judgment, written contract requirements stating, quote, provider will be expected to work 3 24-hour shifts per pay period, and provider's schedule shall include event and weekend coverage, time spent on such shifts, and consequences of not requiring them, namely, other providers must cover additional shifts. Judge Smith rejected Siebrecht's argument that patient care, not shift scheduling, was the essential function, explaining, quote, the term essential function encompasses more than core job requirements. Indeed, it also may include scheduling flexibility. The court emphasized that requiring weekend shifts can be essential functions because spreading undesirable shifts, quote, enhances the non-work life of employees. On reasonable accommodation, the court held reduced work schedule, eliminating 24-hour shifts, and weekends cannot be reasonable accommodation where those constitute essential functions. The court emphasized, quote, both the ability to work all of her shifts, and not just 2/3 of them, and the ability to cover weekend shifts both constitute essential functions. For reassignment accommodation, Siebrecht failed to identify any vacant position she qualified for. The court rejected reliance on a CEO email suggesting she could work at Mercy One because the email did not identify an available position and the Hawarden CEO lacked authority over Mercy One positions. On interactive process, the court held that even assuming Mercy failed good faith engagement, Siebrecht failed the 4th element requiring showing she could have been reasonably accommodated but for lack of good faith, because she identified no reasonable accommodation enabling essential function performance. On FMLA retaliation, the court held Siebrecht failed to establish causal connection between protected FMLA leave and termination. Siebrecht relied solely on CEO deposition testimony about her unreliability. The court held, quote, the CEO's reference to blocks of situations made no statement that her FMLA use played a role in her termination. It was the medical restrictions following the FMLA leave that prevented her from fulfilling the job requirement of 24-hour shifts. Even if Siebrecht established prima facie retaliation, she could not show pretext. The court held providing multiple reasons, inability to perform essential functions and contract expiration, is insufficient to establish pretext when reasons are not contradictory. Further, Siebrecht failed to establish another APP whose TRP expired was similarly situated comparator because that APP verbally accepted contract extension before TRP expired. On interactive process, the court held that even assuming Mercy failed good faith engagement, Siebrecht failed the 4th element requiring showing she could have been reasonably accommodated but for lack of good faith, because she identified no reasonable accommodation enabling essential function performance. On FMLA retaliation, the court held Siebrecht failed to establish causal connection between protected FMLA leave and termination. Siebrecht relied solely on CEO deposition testimony about her unreliability. The court held, quote, the CEO's reference to blocks of situations made no statement that her FMLA use played a role in her termination. It was the medical restrictions following the FMLA leave that prevented her from fulfilling the job requirement of 24-hour shifts. Even if Siebrecht established prima facie retaliation, she could not show pretext. The court held providing multiple reasons, inability to perform essential functions and contract expiration, is insufficient to establish pretext when reasons are not contradictory.
Further, Siebrecht failed to establish another APP whose TRP expired was similarly situated comparator because that APP verbally accepted contract extension before TRP expired.
Analyst comment for this wire.
These four decisions collectively illustrate a judicial trend toward strict construction of procedural requirements and narrow interpretation of accommodation obligations, particularly in shift work contexts. The Pappas intervention ruling demonstrates courts' growing awareness that Rule 23b2 class certifications can preclude individual damages claims, necessitating prophylactic notice procedures even when not statutorily required, a practice likely to spread as courts grapple with the preclusive effects of injunctive relief class actions. The Pennsylvania arbitration decision represents a countervailing force, affirming arbitrators' broad remedial authority to order specific accommodations over employer managerial rights objections when collective bargaining agreements incorporate statutory accommodation requirements, potentially empowering unionized workers to obtain more robust disability accommodations through grievance procedures than through direct litigation. However, the Dunn and Siebrecht decisions reveal that federal courts continue to rigorously enforce exhaustion requirements and narrow essential function definitions in ways that systematically disadvantage disability claimants, particularly where, as in Siebrecht, courts hold that the practical reality of how work gets distributed among employees can itself constitute an essential function, effectively allowing employers to define accommodation requests out of existence by contract. This concludes this edition of the WCAG Wire for Saturday, January 10, 2026.